Okay, guys, I'm going to go ahead and get started. Hi there. My name is Darrell Cartwright, and I'm an attorney in Birmingham, Alabama. And I welcome you today to the uh, video seminar that I'm going to give on estate planning in today's COVID-19 world. And I styled it like that because we have some peculiar and particular challenges that we face with the stay-at-home orders, the pandemic that we are under, and the desire to avoid unnecessary exposure out there. I wanted to talk to you some about that, and also wanted to speak with respect to um, just estate planning, sort of in general. Okay, so we have others that are joining us. I'm going to hesitate for a minute because I'd like to get everybody in that wants to attend this seminar live. I will upload this to the cloud for later purposes in case you want to you missed something or you want to review something that we've talked about. I am an attorney in Birmingham, Alabama. A little bit about me: I have been practicing for over 30 years. My background is I was a Tulane Law School graduate in New Orleans. I practiced law for a couple of years with a law firm, a small to mid-sized firm in New Orleans. And I tell people I lost my mind and I went back to school to get a master's degree in tax law at the University of Miami. From there, I uh, uh, was recruited out of law school to a large law firm in Montgomery, Alabama. Practiced there for a couple of years. Went to Birmingham and practiced with another large firm in Birmingham. And then for the past 20 years or so, I have been on my own or in a very small law firm of which I've been a founding member. Uh, My practice is focused in business, estate planning, tax law. I do business litigation as it comes up, and really about anything that a small, closely held business owner and their family employees might need. Okay, well, let's go ahead and get started about today's topic. Estate planning in the COVID-19 world. Every person that is interested in getting their estate planning done, and that should be every adult in the state of Alabama and others, should have certain documents in their own toolkit. Among these would be a last will and testament, a general durable power of attorney, and I'll explain what that means in a few minutes, a healthcare power of attorney or a healthcare proxy, a living will if that's the consistent with the personal wishes of the individual. Uh, and I want to talk about the Alabama Advance Directive for healthcare. The Alabama Advance Directive for healthcare is a kind of a combination of a healthcare power of attorney and a living will, and it has some peculiar issues that relate to it that I do want to talk about when we get to that point. And then something fairly new, a funeral and burial instructions document that the state of Alabama now permits. Do you need a will? A lot of people ask me that question that have minor children and are really starting out, don't have a lot of assets. And I like to tell them, if you have minor children, you need a will. You don't want to let the children fend for themselves, as the cat would have you do. Some of the things that you want to consider with minor children is what happens if you and your spouse are no longer there. You die in a common accident or something of that nature, and someone is needed to raise your children. it's better if you can select the guardian or recommend the guardian at this point, the person charged with the responsibility of raising the children after you're gone. The conservator for your children can also be selected, and the conservator is the person that would manage the property for the children. Do you need a trust? Under Alabama law, a minor becomes an adult at age 19. So if your child is approaching that age, if they have reached that age, then they're going to inherit whatever property is coming to them at age 19. I don't know about you, but I have several children, and most of them at age 19 would not have been able to be responsible and manage their own property. So a trust can be very advantageous for that. And what happens if they do inherit property as a minor? If you don't have a will, you haven't addressed the conservator situation, you haven't provided for them with a trust or something of that nature, well then you have to go to court and have a conservator appointed. So you're not going to avoid having the conservator appointed. It's just going to be a lot more costly, and it may not be who you'd like to select. And all these kind of things can be addressed in a will. But today I want to talk about a lot of different things, and so I don't want to focus on just families with minor children. I want to focus on everyone globally, and particularly with respect to the pandemic and the public health emergency that we're under. For everyone, having a will can save money. It keeps it out of the greedy lawyer hands. Hopefully the only resemblance I have with him is my hairstyle. Some of the things that can be avoided if you have a properly designed will is waiving the requirements for having your personal representative, your executor, if you have a will, to have a fiduciary bond. That's insurance money. You purchase that from an insurance company, basically, and a fiduciary bond is protecting someone against themselves. They're saying that, look, if you steal money, then we're going to replenish it, and then we're going to come after you and try to get the money back that you stole. It can waive the requirements for inventories, which means further court proceedings that take place. It can, if it's a self-proving will, which is what most wills would be in the event that they're properly witnessed and notarized, then it can eliminate the possibility or the requirement of having a court proceeding to prove that the will was properly executed. And in Alabama, the requirements are fairly stringent to meet for that. And of course, every time that I mention a court hearing or waiver of inventory requirements and things of that nature, that means more lawyer money, and that's money coming out of your estate. Dying without a will means you've got to look at this, the Alabama intestacy laws. I'm always amused when I look at 43-8-50 through 54, and I see that it begins with the word controversy. And that's what you're asking for. You're asking for controversy when you die without a will. It can result in a lot of different issues that come up, in addition to all the costs that I've mentioned in the previous slide that can be avoided. If a spouse dies without a will, there is, a lot of people say, well, it goes to the state. Well, no, that's not accurate. It won't go to the state, but the state will tell you how your property is to be distributed. And generally that's going to go to your family, but it won't necessarily go in the way you want it to go. For example, if you have a spouse and you have children, then depending upon the dollar amount, your spouse won't receive everything. Your children will receive some portion of the estate. And while that doesn't sound bad in principle, do you really want your 14, 16, 17-year-old child, even 20, 21-year-old child to have that property at that age? And the answer is usually no. You usually do not want them to have that kind of property at that time. One of my favorite sayings, Benjamin Franklin, he didn't just fly a kite in bad weather. By failing to prepare, you're preparing to fail. Most people don't have a will. 60 to 70% don't have a will. The artist formerly known as Prince, or that symbol, was one of them that died without a will. Abraham Lincoln was our first president to die intestate without a will. Smart guy, and also a lawyer, but did not have a will prepared at the time of his death. I'm not much of a music guy. You guys probably know this person, Amy Winehouse, but apparently she had a very contentious relationship with her parents. And the last thing she would have wanted at the time of her death was for her parents to inherit her estate. She died intestate, and as a result, all of her estate went to her parents. And again, these are just some isolated examples that can occur that demonstrate that you don't want the state identifying to whom your property should be distributed. You want to decide that today. Can you do it yourself? Back years ago when I was practicing for a large law firm, I had an individual that contacted me from a bank that was a client of ours, and said very proudly that he had done his own will. And I said, well, that's great. Do you want me to take a look at it for you? And he said, I absolutely do. He said, let me fax it over. Now, this is how long ago this has been. It was back in the days when people used fax machines rather than email. So he faxed it over, and I looked at it, and he came over, and we sat down, and he said, did you have a chance to look at the will? And I said, well, I sure did. And I've got good news for you. I said, you have a perfectly valid will that's legal and will be enforced under Alabama law. And he looked at me very proud, and he kind of shrugged his shoulders and said, well, great. And I said, now, you did want to leave $1 to your daughter and disinherit your wife, didn't you? And he just turned crestfallen, and he said, is that what it did? And I said, yeah, that's what it did. What he had done is tried to follow a computer software program that created his own will. And this was years ago, and I assume, I haven't seen one in many years, but I assume they've gotten better. At least I hope so. Because back then, it didn't work the way that he wanted to work. He said, please get it done redone as fast as you can. If there are any Parks and Recreation fans, I love this one. What about doing it yourself just with a handwritten will? Ron Swanson did. Well, a holographic will, which is one that's handwritten, is a good will if you're a Parks and Recreation fan and a Ron Swanson fan, but not necessarily so much for the state of Alabama. In fact, this particular will, the man or animal, would not have been valid even if it had been to a valid beneficiary under Alabama law, because Alabama law requires at a minimum 2 witnesses to witness the will, at a minimum. No politics here, just thought that was amusing. And I don't have this mug. I want this mug, but I don't have this mug. I would very much caution anyone to be very, very careful. Avoid the situation of my bank client. Don't try to do these kind of things yourself if you're not used to doing these kind of things. On the other hand, the fact that you get a lawyer to do it doesn't necessarily mean that that it's going to be done correctly as well. Sometimes selection of the lawyer has something to do with it as well. Now, today is just a brief sort of overview of estate planning and some things that I think may be important for all of you to see and to hear. And so I'm not going to address everything in detail, but I do want to at least brush upon a couple of things, such as special needs and special needs trust that you may need to discuss with your lawyer. If you have a child or other beneficiary with special needs, perhaps they qualify for certain governmental benefits, and they don't have to be a child. It could be, or it don't have to be a minor child. In the event that they inherit property, it could disqualify them for some of the benefits that they are receiving. About 2 years ago, I had to file a lawsuit in Talladega County so that we could make sure that the person did not inherit property that they had inherited because they were under SSI disability and had some other governmental benefits associated that would all terminate in the event that she received this inheritance. And there are ways to address that with discretionary trusts, supplemental trust, things of that nature, but all of which need to be properly addressed at the right time. Blended marriages, second marriages, third marriages sometimes. How do I protect my assets in that kind of situation? A lot of times, just about a month or so ago, I had a couple that I was doing some estate planning for, and it was a blended marriage. We had a prior marriage and children from that prior marriage, and the spouses, as many spouses, most spouses do, wished to benefit the other spouse upon their death. But on the other hand, and this was consistent with both spouses, they both at that time wanted to do the same thing, and that was to make sure that the children from the first marriage inherited at least the property that the first spouse brought into the marriage. And there are ways to do that. You can do that through trust. A lot of people think, well, as long as my spouse has the same will as I do at the time, then I'm covered. And that's not the case. You picture this. You have spouse number one who's been married before with a child from that previous marriage. And spouse number two, they both have the same will. Honey, I love you. In the event that I die, all my property goes to you for your lifetime. At the second spouse to die's death, then the property goes to spouse number one's child. Both have that will in place. Spouse number one dies. Now, what happens when spouse number two meets someone else or for whatever reason falls out of favor with child from spouse number one and decides to change their will? Well, typically there's nothing to prevent that from occurring. There are ways to prevent that from occurring, but they needed to have been addressed prior to the death of the first spouse to die. You can have, Alabama recognizes something called a contract to make a will. That often provides a benefit. The trust that I mentioned, you can have a marital trust that benefits the second spouse for that spouse's lifetime, but then distributes whatever is remaining at death to the child of the first spouse. Things like that, all of which need to be addressed on the front end. Kind of a little summary here. Dying without a will, property may or may not go to who you want it to go to. You can have property go outright to children that are under the age of 19, causing some problems, or even if they're over 19 but not yet fiscally responsible. That's probably a politically correct way of saying it. You can select the guardian. You can select the conservator. Probating the estate is much more expensive in the event it's an intestate estate where there is no will. Titled assets can sometimes, we didn't really address that, but can be more difficult to transfer without a will. And then the judge can appoint the probate representative rather than you. You're probably going to appoint a family member or a close friend that you have a lot of faith in their fiduciary responsibilities and abilities. And that's great. The judge, on the other hand, may appoint your largest creditor, which they're entitled to do by statute. The largest creditor of your estate can be your probate representative. If not, it could be the county administrator. Cha-ching, that means more fees that are coming out. A lot of different things that can occur. But let's move on from the will and talk about some other very valuable estate planning tools, and perhaps even more so in today's world. The first one we want to talk about is the general durable power of attorney. And what can you do with a general durable power of attorney, or what can your agent do? Well, you as the principal would appoint someone else you trust as the agent to act for you and on your behalf, to take care of financial and legal type of obligations, pay your monthly mortgage, your rent, collect debts or accounts receivables, money that you're owed, apply for benefits on your behalf, manage your investments, take care of your tax obligations, file your tax returns, hopefully get those tax refunds, etc. These are the kind of things that in the event you are incapacitated, you may not be able to do for yourself. And there are basically two different types under Alabama law of general durable powers of attorney. And let me go ahead and mention this. Durable means that it endures your incapacity. In other words, if it wasn't a durable power of attorney, if you became incapacitated, then it would no longer be valid. And of course, that's when it's needed the most. So you want to make sure that the power of attorney is a durable power of attorney. General just means that it covers everything. Generally, it's not limited in any way. And then the two basic types of general durable powers of attorney in Alabama are either a springing general durable power of attorney or a sprung general durable power of attorney. And the difference between the two really relates to when the general durable power of attorney is effective. A sprung one is effective immediately. And while that sounds great, that's not necessarily the most prudent course of action to take. You don't necessarily want to vest someone else with the power to act for you, supposedly for you, in right away. You don't need it then. It doesn't need to be in place until it's really needed. So a sprung general durable power of attorney can be dangerous. Let's say that for whatever reason or reasons, your agent decides to use that power of attorney, maybe not quite for your benefit. Maybe they're having creditor issues. Maybe there's just some issues that are out there that you weren't aware of. There's a lot of different things that can occur. Husband and wife do it while everything is wonderful in the marriage, as far as you know. The husband and wife have a falling out. Divorces occur at a rate of about 50%, and you have your spouse with a sprung general durable power of attorney that's not needed. That can create some problems. I'm not a divorce lawyer, I'm not a family lawyer. I'll leave that up to them, but that's a problem. The springing general durable power of attorney, much better, in my opinion, for most people, for almost everyone. It's not effective immediately, but there's a trigger that causes it to be effective. Generally, and the ones that I like to use, the trigger is that two physicians must certify that you're no longer capable of acting for yourself, acting in your own best interest, one of whom must be your treating physician. So it's got to be your guy as well as somebody else, and they are the ones that can certify that you're no longer capable of taking care of yourself, and the springing general durable power of attorney then goes into effect. And that's when it's needed. You're incapacitated, perhaps suffering from some temporary or permanent condition, and that temporary or permanent condition causes a strong need for someone to act for you. That's when the springing general durable power of attorney is needed, and that's when it's effective. Now, healthcare power of attorney is one that is often confused with the durable power of attorney, and they're two different documents, and they do two different things. You'll hear this called a healthcare proxy or a healthcare power of attorney, or sometimes a medical power of attorney, and these are all referring to the same type things. What do they do? Well, it again vests a third party, again called your agent, to act for you in the event that you can't act for yourself, but as it relates to your health care. Perhaps you're in the hospital and there are different types of treatment that can be associated with your health care, a surgery, a more conservative non-surgical treatment, etc. The health care agent would be the person that the hospital and the doctors and the surgeons would look to get that authorization to act for you and on your behalf. Often, husband and wife think they don't need that because hospital's going to listen to wife, hospital's going to listen to husband, whomever it may be, and that's often the case. However, you may not have spouse that is around. Maybe you're in a common accident together, particularly for my younger clients that are healthy and have every reason to believe they're going to live for a long time. Accidents do happen. You have a common accident or a spouse suddenly dies unexpectedly, and then your successor agent. And that's what's wonderful about these documents. You don't have to name just one. You can name one person as your agent, a successor agent, a further successor agent, and really as many as you want or need. And when that occurs, then that person steps up and they become the one that acts for you and determines your health care in the given situations. Perhaps you have multiple children and you want your oldest son or daughter to be that person. They're the most responsible and perhaps less emotional and can make good, sound decisions without falling apart at that time. Or maybe it's your youngest. It doesn't have to be the oldest, but you can make those kind of decisions. Or maybe it's your brother or sister. It doesn't necessarily even have to be a child. Very important document. Now, here's something that I sometimes have disagreements with other attorneys on, and I want to give you my perspective on the Alabama Advanced Directive for Healthcare. This document is approved by the Alabama legislature, and you can find it. Most hospitals have some version of this hanging around. It's a 5-page document. It's a fill-in-the-blank document, either with names or initials. We'll see that in just a minute. And it attempts to combine the healthcare power of attorney with your living will, which we haven't talked about yet, but we'll talk about in a minute. What I'm recommending to my clients is to be very, very careful with this document. It will contain provisions that identify very specific medical treatment, and it allows you to tell your physicians whether you want that medical treatment, that specific medical treatment, or not. It generally tells the physicians how you want to pass away in the event you have a terminal condition where you're not going to recover or you're in a permanent unconscious or vegetative type state. Be very careful with it. I had 2 physicians as clients years ago, right after this first came into being, and I had some concerns with it at that time, and I told them that, you know, of all my clients, you being physicians, I feel most comfortable with in using this document as opposed to a healthcare power of attorney, naming someone else, and a living will, which generally describes what your intents are. And they both looked at me and immediately said, oh no, we don't want to have anything to do with this. We don't like it. We'd rather our treating physicians determine exactly how our care is going to be, given what our wishes are. And they did desire a living will, but they didn't want to specifically identify the treatment at that time. And that just told me, that was a red flag to me. That told me that we needed to be careful when we use this document. And there can be some oops situations that exist. Uh, the document itself provides for you to put your initials in the blank. You know, what happens if you do as I did there in the bottom left-hand corner and marked an X rather than your initials? Is it effective? Will the hospital and physicians and surgeons respect that if it's not initialed? And I say it probably wouldn't. Moreover, in my opinion, there are some internal possible inconsistencies, and I've identified one here. I want to have life-sustaining treatment if I'm terminally ill or injured. You say, no, I don't. And then you say, well, I want to have food and water provided. Well, isn't that life-sustaining treatment? So there's an inconsistency that's permitted by this document, in my opinion, and I have some concerns with any document that allows something like this. So be very careful. If I have a client that wants to use the Alabama Advanced Directive for healthcare, I'll do it after expressing my concerns, and we'll go through it page by page very, very carefully to make sure that that's exactly what they want to do, but I'm not a big fan of it. A plain old garden variety living will is a document that has been around for many years, and it's a declaration. It's a declaration that says, hey, in the event I have a terminal condition for which there's no hope of recovery, it is my desire to die naturally without the use of machines to artificially prolong my life and with using only comfort care, medicines, and treatment designed to alleviate my pain and suffering. I'm a big fan of that if that's consistent with your wishes. And I don't make a personal recommendation for a living will. That's up to you. The general durable power of attorney, I'll bang my fist on the desk and say, please let me put that in place for you. Your health care power of attorney, same thing. And of course, the last will and testament with everything that goes along with that. Those are just absolutely mandatory. The living will is a personal decision that I'm going to leave up to you. Alabama recently, and I say recently, this is showing my age, but in 2011, implemented a brand new statute that allowed you to advise people or advise others exactly what you wanted to have happen after your death with your remains. You know, did you want to be buried? Do you want to be cremated? How about embalming? Is there a specific casket kind of situation that you want? And this isn't the same as a pre-planned funeral. This is actually sort of a combination of a power of attorney with a living will, but after your death kind of document. It allows, by statute, you to identify the person who would be responsible for making those decisions and carrying out your wishes if you've identified what those are after your death. And this document's a very simple document. Almost every one that I've done for clients has been 1 page long. And what this actually does is this. If you have a family and the family, maybe you have 3 or 4 children, a spouse or no spouse, And there may be concerns about them not getting along after death, and there may be concerns about, well, dad would have wanted this, mom would have wanted that. This actually identifies the person. There needs to be sort of a tiebreaker, and this is the person in charge. This is the person that would make the decisions and tell the funeral director or tell whomever exactly what needs to occur in those situations. Again, not necessary, but very helpful in certain situations to prevent family discord. Now, in today's world, the COVID-19 public health emergency, the pandemic that we're under, most of us are under, or I guess the entire state is under a stay-at-home order. We do have some exceptions, such as lawyers for legal services and other essential businesses and operations, and we're still permitted to work. But none of us really want to unnecessarily expose ourselves when we don't have to. And here's where we have something that's brand new under Alabama law, never allowed before. Uh, the procedure normally for your estate plan is you talk to the lawyer, maybe by telephone, maybe in person, um, exchange emails, perhaps, information. And then when the documents are prepared, the lawyer sends it to you. Documents are revised, they're supplemented, they're corrected in some situations. That's what drafts are for. Um, and when it comes time for the finalization of those documents and when they are ready to be signed, then you arrange a will execution conference with the attorney where you have two witnesses, a notary public. You go to their office generally. You handle their doorknobs. You push open their doors. You walk into their conference room and sit down at their table, grabbing their chairs. You sign their papers, often with their pens. Sometimes you shake hands with the witnesses and the notary public and the lawyer. All of these things in today's world can subject or expose someone to the coronavirus. And it's because of that, Governor Kay Ivey issued her fourth and fifth supplemental state of emergency proclamations that provide some relief for us in certain circumstances. The fourth supplemental state of emergency allowed for notaries who are attorneys, such as myself, and for notaries who are employed by or supervised by attorneys to utilize video conference technology and to deem witnesses and notaries and testators to all be in the presence of each other if video conference technology is utilized. And then the fifth supplemental state of emergency even expanded that to allow for other potential notaries in certain situations with some other requirements that they must meet as well. What this does, it doesn't really change the law as much as it changes the procedure. Witnesses and notaries can be deemed to be in the presence of each other. Now, how does this work? 2 nights ago, I did a video conference will execution for an individual who was in poor health, undergoing, it's not related to coronavirus, but in poor health, immune compromised, and undergoing an operation later this week. That individual did not need to get out. That individual didn't need to be in the presence of anyone else other than his or her medical providers. We exchanged documents, talked via video conference to begin. We got the documents finalized. This person printed out the documents at their home And I had it printed out actually at my home office. And part of the benefit of being a part of a large family, I always have built-in witnesses available. Just grab a kid home from an online break in college. Um, and we performed the will execution conference right then and right there via video conference technology. We did it properly, we did it legally, and we did it safely. That individual now has an effective will, general durable power of attorney, and healthcare power of attorney, as well as their own living will that is effective and valid under Alabama law, and it never was allowed before. This is a game changer. Now, I don't know that this is going to continue. Uh, and just being frank, this also helps attorneys like me service clients from all over the state of Alabama during this pandemic. Uh, Before I have clients in Huntsville, I have clients in Anniston, I have clients in Mobile, all over the state. But it usually requires some logistics of me traveling there, trying to gather up several different client meetings for several different clients in that area if I was going to travel to Mobile, um, or waiting until the client traveled here to Birmingham for whatever reason, or meeting somewhere in the middle. Well, now that's not required, or at least during this national during this public health emergency, it's not required as long as we're under this procedure. So I'm urging my clients to take advantage of it at this point. And again, who really wants to go to a lawyer's office anyway? The procedure for executing estate planning documents is very important. It is a formal procedure. A will must be witnessed by at least 2 witnesses under Alabama law for it to be valid and effective. And a notary public must notarize the document so that it's self-proving, and that eliminates the necessity to go to court and prove that the will was validly executed properly under Alabama law. Your health care proxy or health care power of attorney must also be witnessed by 2 witnesses, as well as the living will. The general durable power of attorney is very interesting because under Alabama law, it doesn't even have to be notarized and it doesn't have to be witnessed. Now, Alabama law also provides that nobody has to accept it if it's not notarized. So it's kind of a toothless tiger if it's not notarized. I've never seen one that wasn't notarized because it's useless. But technically, just from an academic chuckle standpoint, it doesn't even require a witness. Uh, and funeral and burial instructions also have to be notarized to be effective under Alabama law. And all these things need to be done properly and legally and formally. The Governor Ivey's proclamation allows them now to be done remotely via video conference technology. Ladies and gentlemen, this will conclude the estate planning video seminar that I have. My intent was to make this 45 minutes or less and let you get back to eating that sandwich. I appreciate you being here with me today. And if I can help you, or if you have your own estate planning attorney, that's fine. Please be sure to talk to him or her about some of these concepts. And I will again, I'm going to have this recorded. I'll have it on my website later in the event that you needed to come back and check on anything. And if I can ever help you, I'll be happy to do so. You guys stay safe, wash your hands, stay at home, and I hope to see you in person soon. Thank you. God bless. See you soon.